Hello, it's Philip Taylor speaking from Richmond Green Chambers. This morning I'm looking at a book from Jordan's, not actually on family law this time, but on insolvency. The book is actually now in a third edition, and it covers insolvency law in the title, and it covers both corporate and personal insolvency in the one volume, which I think is very good. So I've given it the title Striking the Insolvency Balance, because this book is actually slightly different from some of the texts you may have seen on insolvency law in the past. It's been written by Professor Andrew Kay and Dr. Peter Walton, now in a third edition. What it's doing is, because of personal debt and business rescues increasing at a fairly alarming level, non-specialist practitioners are beginning to find their work affected by either corporate or personal insolvency to a larger extent. So this book is actually a timely use to people involved in that area. In the preface to the third edition, the authors say that insolvency law does not stand still. We're quite right about that. Practitioners and judges alike show an inventiveness and pragmatism second to none. Since the previous edition of this book, we've seen any number of developments, some expected, some unforeseen, some major, some relatively minor. And they then cover that by saying insolvency law has continued its journey towards being a significant, discrete area of law, demanding study in its own right, and not just as a bolt-on to the end of a company law syllabus. Because in the past, of course, company law, when I read law, insolvency was just a little part of the overall company law syllabus itself. What we've got, of course, is cross-border issues now dominating the proceedings at quite a substantial level. This is the book, anyway. Let me show it to you. It's a heavy book. Spine, and then there's the back. There's a nice quote from the Cambridge Law Journal, which is well worth reading. What you've got is a standard structure for the book. Right at the back you've got the index, which you can see, last page there. It's 700 odd pages. You can see a bit more of the index there. 700 odd pages altogether. The actual structure of the book is good in that you have the paragraph numbering, which you can see at the sides there. So you've got the chapter number and then a number to go with it. And you do have, with Jordan's, you have footnotes at the bottom to go into more detail should you need it. But as I say, there are also very useful points at the end of each chapter, which are the references, which are extremely helpful, because that will give you a chance, if you're looking for something very detailed, to go into much more detail. This is the contents section here, and what you've got right at the front is the preface to the third edition, which I've just quoted from, which is there, and then there's a preface to the first edition. And there are obviously a lot of cases, depending on what you want. This is not the same book as the ones that you will see in court. There's the introduction right at the beginning. This is not the same type of publication that you would have as a practitioner. But what Jordan's have done here, in my view, is to produce something which brings both areas together in one easily readable statement of current law. And obviously the third edition, being the end of 2012, is extremely useful because it's written in a detailed but a straightforward way, making it accessible both to practitioners and to students. And I think also people who are the lay clients will find this of quite some use in trying to understand what is a technical area and for most people extremely worrying area of law. It's a comprehensive book which explains both the legislation and the cases in both areas, corporate and personal. And it also looks at the procedures available, which I think again will be of help, rather than going to the practitioner works themselves, which are frankly daunting. There have been a number of revisions to the third edition. Obviously there's an expansion of the material on international insolvencies, which has become much more important with the global market expanding. It looks at the changes to the insolvency rules and looks at a lot of case law, and also one area which I found interesting, it examines how football creditor rules operate under the CVAs, which again will be of great help, I think, to many people. As I've said, with the footballing analogy, which is mentioned in the third edition preface, the UK, they say, is in the Premier League of insolvency law jurisdictions, and I think with the way things are going with the economy, that is not going to change in the near future. I'd like to thank Professor Kay and Dr. Walton very much for the new edition. It's a very great help, and always right at the top of the list, because Jordans really are an eminent publishers of this type of material. Thank you to all concerned. Bye bye.